vacancies are being forwarded to the professional examination board, my lord, to fill in. If they are being permitted without going on to the aspect of regularization, our employer, that is municipal corporation, my lord, then it will be actually directly in contravention with the judgment passed by the division bench of this court. Now, professional examination board.
What about the other petition, 53?
53, my lord, the facts which my friend is narrating, those are applicable in the municipal corporation case because the employees had earlier come. My lord, we are the employees of other department, state government department.
Common examination.
Though issue is almost, my lord, similar because here also these petitioners are working for years together without regularizing them, and they earlier, my lord, they were subjected to same examination and they qualified in that examination. But again, they have, my lord, been subjected to this examination, and that is why these orders were passed. That what is the?
Are you aware of this order in?
Yes, I am aware of it. I've seen it.
You are opposing grant of this.
I'm not opposing it. My lords have already taken a view, my lord. I cannot, as of now, my lord, I don't have as such. And my submission would be, my lord, it will render the earlier order passed by, because third party right would be created. The entire posts are.
Correct. That has to be heard then.
Yes. My submission is there is.
Actually, what prevailed on us is that at least for the present.
Yes, I've read that order. I am not.
Process
Yes.
Next time we can't stall it.
I've read it.
Then if you want to hear it, then we are unnecessarily pressurizing ourselves to take matters out of turn.
Yes.
But to be fair,
Submission
so
would be,
we
my lord,
pass that order so that
if there would not have been any order, my lord, crystallizing our rights, my lord, now since it has been crystallized by the division bench and the Honorable Supreme Court too, so at least they should it is by the professional examination board, it is just the examining body.
Yes.
My employer has not come up and said that this interim order granted is bad in law, because they are the one who has to recruit, and they have to argue that why they are not resorting to regularization, my lord, in terms of the orders passed by the division bench of this court, and again, my lord, sending these vacancies for direct recruitment. Now, professional examination board comes up and says that they will be permitted to complete the exercise. It is for my employer, at least, my lord, the corporation should first, my lord, clarify their stand, my lord, and they should, my lord, primarily
who's for the corporation?
I am appearing for the corporation.
Your
Lordship, in this, the corporation is working under the urban administration department. They have issued us, and we are just we have filed Annexure R41. In that, we have just we have been directed to supply the information of the district-wide vacancies. That is all we have done, and the annexure is at page number Lordship R41. That is. That letter may kindly send. In light of that letter only, we have sent just the vacancies that are vacant district wise.
you are for the corporation?
Lordship.
R4. Huh?
Yes, Lordship. Respondent number 4.
You hold wakalat?
Yes,
Do you have your wakalat?
yes, Lordship.
Are you engaged by the corporation?
Lordship, Mr. Vijay Singh Chaudhary is the standing counsel, but right now he has his leg before another bench, so I am appearing.
How and what authority you can appear for the institution when you are not authorized to appear?
Lordship, I have filed my power, but
Have you been engaged? Are you standing counsel for the
no, Lordship, I am not. I am certainly not the standing counsel.
We understand a lawyer is appointed by the institution. His office is not appointed.
Lordship, if I may be permitted, I just call my face.
Yes, please bring it.
Lordship.
Wrong, counsel. The practice being followed is not correct. In private briefs, you can send your juniors, but when institutions are involved.
I just make a scholar.
Yeah, please. Is that particular advocate who must appear? Can't send her. Pass it over. So the other cases?
5.23 So 53.31. In this case, my lord, in a later round of litigation, the employer has, my lord, admitted that, my lord, against 65 posts, right of petitioner may be considered. And therefore, my lord, petition was disposed of. Thereafter, my lord, when they have taken a decision, within, my lord, 3 or 5 days, my lord, they have taken a decision, there is no proposal for, my lord, regularizing the, my lord, sub-engineer, my lord. And within a week, my lord, they have sent, my lord, vacancies to the, my lord, professional board. My lord, may appreciate page number 151 of my writ petition. This is the reply filed in earlier round of litigation, in earlier writ petition. Para 6, my lord. That in the instant case, 65 posts of sub-engineer civil and 23 posts of sub-engineer electrical are sanctioned by the government. Therefore, the petitioner can only be considered for absorption, regularization of their contractual
In
services.
which writ petition you are reading?
This is, my lord, 18038. This is, my lord,
So
53.3.
what is this connected writ appeal 1161? Same petitioners have filed writ appeal 1161.
But interim relief was not given.
That was earlier filed for, my lord.
They preferred a writ appeal.
Earlier, my lord, because, my lord, for not considering my interim relief, my lord, earlier writ appeal was filed.
That was disposed.
That was disposed of, my lord, with liberty to press it before the learned single judge. So, my lord, earlier my employer has been, my lord, admitted. My right may be considered against this, my lord, these posts, my lord. Page 151, my lord.
Who is your employer here?
This is Madhya Pradesh Police Housing Corporation, my lord.
Who appears for this?
Mr. Pankaj.
My Shish Pankaj Dubey here, my lord, he's on his leg before the other, so he'll be coming in a while.
So filed your reply?
Yes, my lord, we have filed the reply.
What is your stand?
My lord, firstly, my lord, my stand is that the policy has been floated by the state government. My lord, it is the policy which has to be, we have just followed the policy in the way it has been provided. The policy is subject by the state government.
He is arguing that you have conceded his entitlement.
No, my lord, that is not the case, my lord. My lord, what has happened, my lord, earlier they have filed a writ petition, it has been directed to consider vacancy as and when arise. When they prepared an application before us, at that point of time, there was no vacancy. My lord, later on, the vacancies were called. Then we sent these vacancies to the professional examination board, and then it has been that advertisement has been published. And my lord, so far as their right is concerned, they are well covered within the policy. If, according to the policy, they have to apply within the policy, and then only they will get. If nowhere their right has been hampered or
It's not only the issue.
20% out of?
Whatever vacancy is advertised, 20% will be earmarked for the existing actually. Once he further provides that if he is an employee of X department.
So he has to also go through the selection
yes,
process.
my lord.
And he cannot, if he is an employee of X department, then he apply for Y department also. Fulfilling the criteria, 10 years age relaxation, plus 20% quota.
No, my lord. Policy is available at page 140, my lord. That stated that all the contractual posts should be converted in the regular post and contractual employee be regularized. And in such a case, my lord, if any advertisement of issued in any of the department, then 20% post for reserved for that category.
Where kindly show the
140, my lord, page 140.
40.
140, my lord.
Ah.
This is, my lord, विषय संविदा पर नियुक्त अधिकारी कर्मचारियों को नियमित पदों पर नियुक्ति के अवसर प्रदान किए जाने हेतु नीति निर्देश राज्य शासन के विभिन्न विभागों एवं मध्य प्रदेश राज्य रोजगार गारंटी परिषद, राज्य जिला स्वास्थ्य समितियों, मध्य प्रदेश सर्व शिक्षा अभियान मिशन में संविदा पर नियुक्त अधिकारी कर्मचारियों को नियमित पदों पर नियुक्ति प्राप्त करने के अवसर प्रदान किए जाने हेतु निम्नानुसार दिशा निर्देश जारी किए जाते हैं। संविदा अधिकारी कर्मचारियों से आशय है वर्तमान अथवा पूर्व में संविदा पर कार्यरत अधिकारी कर्मचारी। नाउ 1.1 इज इंपॉर्टेंट मानो, राज्य शासन के विभिन्न विभागों के अनुमोदित प्रशासनिक सेटअप में संविदा पर नियुक्ति के लिए जो पद चिन्हित हैं उन्हें चरणबद्ध तरीके से नियमित पदों में परिवर्तित किया जाए।
What that means, Tripati?
So it means, my lord, those posts, my lord, which, my lord, sanctioned as a for contractual employees, my lord, that should be converted in a regular post, my lord.
Converted into all posts
Yes.
immediately.
नहीं, चरणबद्ध
In a
तरीके से।
phase-wise manner. In a
phase-wise
phase-wise
manner.
manner.
But this policy issued in 2018. My lord, now that after 5 years, they have not, my lord, processed this, my lord, very condition. Even a single person has not been regularized in my lord, compliance of this. So this said, my lord, प्रशासनिक setup में.
What is their answer in the return?
Their answer is, my lord, they are saying, my lord, only 20, the right of contractual employee is only up to the 20%. Whereas that is for, my lord, general recruitment. If any advertisement issued by the state government, department wise this policy is applicable.
20% comes from where?
वो किसी को भी रहेगा, जो भी कहीं का भी अगर कॉन्ट्रेक्चुअल एम्प्लॉई है, अगर सपोज मान लो
Policy is there.
सेम पॉइंट।
Para 1.4, my lord, on the next page, para 1.4. It says प्रत्येक विभाग के भर्ती किए जाने वाले पदों में 20% पद संविदा पर नियुक्त अधिकारियों कर्मचारियों के लिए आरक्षित रहेंगे। 20% posts are directed to be reserved for these contractual employees.
How do you reconcile 1.1 and 1.4?
Yes, if we read, my lord, this para 1.1, they say that the posts which are presently on contract basis, those posts in the phase-wise manner, they will be converted into the regular posts. And then they say that the available posts which are available posts as on today, my lord, on the date, those posts will 20% posts will be left, my lord, reserved for the candidates who are contractual employees. So, my lord, if these two are read together, my lord, they are not required to undergo any process of selection, as they are being subjecting them, because earlier also the contract appointments have been made by undergoing the selection process. Contract appointments were also made by the similar process, and that is the objection, my lord, that how many times these candidates will undergo the same process of selection.
To go by 1.1,
My lord,
that means the contractual appointments should be made on a phase wise.
contractual appointment already made should be converted to regular appointments in a phase manner. Yes,
So today or tomorrow it will be over.
my lord.
So all contractual employees will become regular employees.
My lord.
Correct?
Yes.
Then where is the question of 1.4 thereafter?
1.4 would be,
If
my lord.
everybody is going to
onwards.
become regular,
My lord.
so how do you reconcile 1.4 is intended for whom?
But if they fill up all the posts by way of direct recruitment, then there would not be any post available for the, because they say that contract, otherwise if this,
No, one by one.
my lords,
According to you, they should all be converted to regular,
my lords,
phase wise.
yes,
So let us say 5 years they fill it up.
my lords.
So all contractual employees today, after 5 years will all become regular
Regular employee,
in different
my lords.
stages. If that is the position, then what is this point of giving 20%? 20% किसके लिए?
वो सब उसके लिए है। If in some of the department, if there is no contractual employee, they have advertised the post, and the contractual employee working some other department. तो एक प्रत्येक उसमें लिखा है, प्रत्येक विभाग के इसमें आए, प्रत्येक विभाग में भर्ती किए जाने वाले. तो if in every मतलब recruitment process of every department, so in such model there is no contractual employee. Even then they required to reserve 20% post for contractual employees. So the contractual employees of other department may be participate in that process. This is the purpose to provide.
संविदा कर्मी के लिए आरक्षित की गई सीधी भर्ती के नियमित पदों पर प्रतिस्पर्धक तरीके से प्रक्रिया के माध्यम से चयन होगा। इस चयन प्रक्रिया में नियुक्तिकर्ता विभाग द्वारा न्यूनतम कट ऑफ एवं निर्धारित किए जाएंगे।
What are you reading? 1.?
1.10 at page number 142.
What is it?
My lord, जो पोस्ट है उनको कॉम्पिटिटिव मैनर में ही कन्वर्ट किया जाएगा।
What? Please read that.
संविदा कर्मियों के लिए आरक्षित किए गए सीधी भर्ती के नियमित पदों पर
What is सीधी भर्ती?
डायरेक्ट
How it is? For direct recruitment.
1.16 भी देखें my lord।
What is your reply to 1.1?
1.4 में जो 20% के पोस्ट आरक्षित हुए हैं ये इन्हीं के लिए है।
ठीक है
जी।
What about 1.1?
My lord, 1.1 cannot be wrote as an independent. Entire policy has to be read. But 1.1 is read.
You read ultimately what is your understanding of it? You are the employer, no?
Yes.
So how do you read this policy?
My lord, this policy has been floated by the state law. My lord, we have adopted this policy. My lord, we have certain vacancies, and of course we have given this vacancy to the professional examination, and they have now issued the advertisement, my lord, on the basis of that. My lord, what is to be clear that all those posts have to be converted. There are 20% of posts reserved specifically for them in this regard, for the contractual.
That is a different category than 1.1. 1.1 you have to regularize them in stage wise.
For this, I believe this is the policy of the state government. State government would be in much better position to answer about the 1.1.
How are you implementing it?
My lord,
What is your understanding of this?
my lord, our understanding is that we have given this.
That only 20%.
Yes, ma'am.
Yes, Amit.
Not 1.1 does not talk of it. He says not that wherever they are existing, they will be in a phased manner converted to regular. So this talks about only conversion. This does not say that the persons who are working on the contractual post they will be converted. Does not say that comes to not because those posts will be now available for direct recruitment and therefore not 20% reserved. This is in addition to the post which will be available in future apart from the existing post. But not that the persons who are holding the contractual employment, they will be regularized on that. This is somewhat not set up in number. If it is regular, it talks about regular. Simply says, राष्ट्र शासन के विकसित विभाग में शासनिक सेटअप में संविदा का नियुक्ति के लिए जो पद चाहिए ने चरणबद्ध तरीके से नियमित पदों में परिवर्तित किया जाए। पोस्ट आर टू बी कन्वर्टेड एज रेगुलर पोस्ट। विषय विशेषज्ञता योग्यता एवं अनुभव अथवा ऐसी कोई विशिष्ट परिस्थितियों में संविदा का हित करने के लिए पद स्वीकृत किया जाए। दिस इज एडिशन टू नॉट व्हाट इट इज।
For post will be regular. तो yeah, submission के तो जाना ही पड़ा. This will be converted. So you got to go to Sub Engineer as per this 14. तो जो 20% पद है. नहीं स्टेट में है. उसके बाद जो 20% तब तक प्रत्येक
They have to will not face one regular recruitment examination or a regular appointment
So according to you, all contractual posts
in a phase-wise manner.
become regular.
In a phase-wise manner, they will be
They
converted.
become regular.
Right.
Once they become regular, you go for
This
recruitment.
is a continuous process.
And after and in recruitment, 20% is reserved.
That is there. There cannot be direct regularization of the contractual employees. They have to because 1.10 is also to be read, not 1.12.
That may not.
20% we are not taking care of the posts which are converted in a phase-wise manner to regular recruitment posts. If they are the post of direct recruitment, not, they will have to follow the policy not as and when the situation arises. As on date, they are entitled for 20% reservation all departments. Since they are contractual, at 10 years, they complete as a total. This policy talks about this only, not this lower says not that they have to face examination, then if they succeed, they will. Else, unless the posts are not converted, they will continue, that's a return, that's a not. But they have the choice to participate under the action quota.
My friend, what my friend says, my lords, may have a look on paragraph 1.14.2. 1.14.2. Internal page 3 और लास्ट. वर्तमान में संविदा पर नियुक्त अधिकारियों कर्मचारियों को इस नीति के अनुरूप विभागों द्वारा उन्हें नियमित नहीं कर दिया जाता, तब तक प्रत्येक वर्ष की जनवरी में वार्षिक वेतन वृद्धि आलोच्य अवधि में उपभोक्ता मूल्य सूचकांक में वृद्धि के आधार पर देय होगी. यह राशि निकटतम 100 रुपए के गुणांक द्वारा पूर्णांकित की जाएगी. उपरोक्त अनुसार वार्षिक वेतन वृद्धि देने के लिए आवश्यक होगा कि संबंधित संविदा सेवक ने कम से कम 6 माह की सेवा अवधि उस वेतन में. They say unless these contractual employees are regularized. मालूम में प्लीज सी इट स्टार्ट्स फ्रॉम वर्तमान में संविदा पर नियुक्त अधिकारियों कर्मचारियों को उस नीति के अनुरूप विभागों द्वारा उन्हें नियमित नहीं कर दिया जाता. Until they are regularized, then Manoj, they are given these certain benefits which are flowing out of this clause. So they say that they are to be regularized. These contractual employees are to be regularized, and until they are regularized, they will be given these benefits. So it's not that the policy does not talk about their regularization. What Mr. Seth has said, Manoj, clause 1.1, it says Manoj, conversion of the contractual post in the regular post. Manoj.
Consequence to non-regularization.
Yes.
It's the clause on regularization.
Manoj, it says Manoj, unless they are regularized.
Correct, but that read negative into it.
Manoj. Now, otherwise,
There
Manoj,
should be a clause which regularizes your.
Manoj, in fact, this policy itself, Manoj, it says that
This requires to be heard.
Manoj, the only prayer,
Interpreting how they are interpreting.
the only prayer in these matters is
all the contractual employees,
this could be, these matters could be heard about because there are hundreds of employees who are.
But they are undertaking that they will not terminate you if they. You are still entitled for that.
Manoj, that apprehension was not.
For the time being, at least.
Manoj, that
The
apprehension.
interim measure, are you not protected to that extent?
That apprehension was not there, Manoj. Removals apprehension was not there.
But once they have filled up they
Yes.
have not left 20% post even. If all the posts have been filled up, then the employees, contractual employees, who claiming right as per this policy, as well as the some order of honorable courts, once they have been fulfilled the post, then they cannot.
They will be subject to further orders of this court.
My case, earlier
So
they
assuming you succeed, you're entitled for regularization from the day you claim it.
in my case, earlier they have been considered. If my lord may appreciate, employer considered their right up to those posts, they are required to be regularized. Beyond that, we cannot accept it. If my lord may appreciate 151, page number 151, which return they have filed before the my lord, this court in earlier petition, they said, मैं एक बार पढ़ देता हूँ सर, that in the instant case 65 posts of sub-engineer civil and 23% posts of sub-engineer electrical are sanctioned by the government. Therefore, the petitioner can only be considered for absorption, regularization of their contractual service in terms of policy meant for contract by the state government, which may be applicable to all other departments as well. there are only 65 posts of sub-engineer civil and 23 posts of sub-engineer electrical as enumerated above, which are sanctioned. The answering respondent do not any authority to consider regularization of contractual employee or officer beyond the aforesaid 65 posts of sub-engineer civil and 23 posts of sub-engineer electrical. So earlier they have admitted, against this post our right has been accrued and they will be considered. On the basis of this, earlier the petition was disposed of. All right, you take it, you proceed this. Within a period of 7 days, my lord, they passed the order. There is no proposal for regularizing the for regular appointment. Therefore, we cannot regularize you. And within 7 days, they have sent vacancies to my lord professional board.
We need some interim arrangement to protect you.
My lord, in this case, my lord, there is no interim relief. In my case, my lord.
Same relief as in the other cases also for.
Yes.
Can't leave them without any. In the other order, we are permitted to go ahead with the selection process.
This is all what we know. Same that at present we have. Whether the situation. Don't know, Lord, because their posts are very limited. Lord, that is to be answered by.
Yes.
My lord, so far as this police housing corporation is concerned, the return which is read before my lord only states that what number of vacancies are available. We depend upon the policy. We had vacancies and the vacancies were reported to the state government.
That we'll hear some other day. In the other case, the government said that they are not going to terminate any contractual employees. Is that the same situation with you?
I don't have such instructions, my lord, but I can definitely take such instructions.
Direct you not,
Similar to.
you direct you not to remove them.
No, we'll follow. And the process may be allowed to be continued.
The same order. Are you aware of that?
Yes, my lord, we are aware.
What do you say?
Our case, one of the difficulty was probably 6 months. The vacancies are limited with the municipal court.
But again, we have to hear on that call.
Yes. The thing is, if they say, if they undertake,
We want some protection to be given to you till.
but that protection is very much available as such the interim order is concerned. My lord, what I've modified, I've gone through it. I don't dispute that the protection is very much available there. Submission would be, my lord, that in future what will happen if these persons are selected and the vacancies are limited, we will not be regularized for all. In our case is different from other case is, my lord, that earlier also they have issued the same advertisement. We challenged it before this too. Now the right got crystallized in Supreme Court. They could have very well, my lord, conducted an exercise of regularization. If not possible, my lord, reject our claim and then could have proceeded in terms of filling up the rest of the vacancies through direct recruitment. Now what they are stand in the reply is, my lord, that the state government says that please give us the vacancy. Now the state government puts an embargo in their circular, my lord, that all vacancies which have been forwarded or Group C and Group D will not be filled up through regularization or compassionate appointment till the selection process is over. So submission would be, my lord, that this will be in directly contravention with the division bench order, which is upon.
Prima facie, what you're saying is correct.
Yes. Then that is the submission, my lord.
But to come to that conclusion,
I've gone through the interim, modified
no,
interim.
that's correct. No, prima facie, what you're saying is correct.
Otherwise,
It will run contrary to this.
if they undertake, my lord, that despite this exercise in near future or during the pendency, if they conduct an process of regularization, it will not be rejected for any employee as such on the count that there is no vacancy.
No, they cannot do that.
That's it.
They will not say those.
It would be,
By and large, it has come to a situation where even for regularization, you have got to go through some process of.
yes. But then this order, my lord, will render it ineffective, my lord. The earlier litigation
Yes,
would be.
that's right. For the time being.
Yes.
For the time being, yes.
नहीं कर दिया जाता तो हाँ ये बात नहीं नहीं कर दी
But what other arrangements do you
Today
take?
it was, all due respect, because of this particular deadlock, Malord, this honorable court was of the view that
Yes.
we heard. So if it can be taken up for hearing on Monday or any date, Malord, and Malord may pass orders, that will suffice.
No, we had a detailed interim order last time.
If your lordship, then Malord, these are the submissions.
There is another issue also there. The reservation has Malord, been extended up to 73%. That is all.
Solve this first. It also has to be- No, obviously, we are going to say that it is all subject to order.
The appointments will be
Depending on-
provisional, kept provisional also.
Huh?
The appointments will be kept provisional, but this is basically they are bypassing the orders passed. By this
But
particular.
they can't survive forever like that.
Has taken us to an endless loop. That's it. They'll keep on doing it in that manner, then it would be more difficult for us to
Yes.
see any assistance from
Give us
any
advantage.
legit forum.
But the interim order only in 53, is it?
Examination.
But there's
Give us advantage. Give us advantage. Give us advantage.
Only in 53.
53.1.
No, 53.
Order was modified in 53. At present, my lord, only 53.1, there is an order.
What about the other cases?
In other cases, my lord, from the last date of hearing was.
In
53.7 and 53.1,
Ah.
53.7 and 53.
So is there a stay in all the cases?
No, my lord, 50.3.3, my lord, to 3.5. 53.3, 53.4 and 53.5. There is no interim order.
So we grant the same order.
Same order.
Huh?
And my lord,
In which are all those cases?
53.3, 53.4 and 53.5.
Ah.
There is no interim.
Ah. No interim order. Which petitions have interim order?
53.1.
50.
Ah.
There is an interim order restraining us to declare the result.
Now then,
Part 7, though the order has been vacated, but I is still shown to be pending. 7.
okay.
Part 8 will not be.
What about the other cases?
So that will be disposed of. I am appearing in 53.7.
53.2?
On the last date of hearing, my lord, so please modify the interim order.
53.2.
6.2 order modified.
So only these four cases we have to grant the same order. Modified to the same extent. Huh? So you take 53.4 or 53.3, 0.4, 0.5, 0.8 and 0.11.
0.1 as well.
One में है ना?
One में है अकेला.
1 में है तो उसको मॉडिफाई करना पड़ेगा.
What is the corporation Jabalpur, Malord? My respectful submission would be our employer doesn't dispute it. Our employer has not filed any application for vacating stay. To the extent of the vacancies, Malord, available there at Jabalpur, Malord, rest of the
Similar questions of fact and law arise for consideration in WP 18107 of 2020. An interim order was granted initially and later modified on applications for vacating stay in terms of the order dated 3/1/23. Therefore, we are of the view that the petitioners in these cases too would be entitled to the similar relief. Consequently, the respondent professional examination board, in all these cases you are there, are permitted to declare the results and to undertake further processes. However, any further appointments would be subject to further orders of the court. The respondent employer is also directed not to remove the petitioner contractual employees until further orders of this court.
declarations of the results and other process is also subject to the.
Yeah, we have said that.
That is the.
Just the last part also, there are also direction for them in the interim period to be considered for regularization. The last part.
Yes.
That is the.
In the interregnum, the state may also consider the case of the petitioners for regularization in accordance with law.
Or in case
What
of
about point
corporation-
7? Point
Point
7.
7, my.
All these cover point 1, 1, 3, 4, 5, 8 and 11.
Yes.
Correct. What about point 7?
I am appearing for 7. Same order में guide.
Same order?
That IA may be disposed of.
Point 7, no?
We are giving 7.
Point 7. The IA, since an interim order has already been modified on IA number 905 of 23 stands disposed of.
Or in respective cases wherein
53? Point.
वो तो आ गया ना.
small request.
Condemnation or delay for what? 23.8. IA for vacating stay filed in so and so in point 8. Only point 8 में है ना vacating stay.
Point 8 में not in terms of order, it is 3 or 20.
Point 7 is disposed.
Or,
You should only see post hearing.
or